Okay, so it's amazing that you just asked this question because it has just come up in one of my cases. So today we filed our mandatory settlement conference statement, which is a statement that, according to California rules of court, you are supposed to file and serve 5 court days before the mandatory settlement conference. And in that statement, you are supposed to provide a good faith settlement demand, an itemization of economic and non-economic damages by each plaintiff, a good faith offer of settlement by each defendant, and pay attention to this, Bean, a statement identifying and discussing in detail all facts and law pertinent to the issues of liability and damages involved in the case as to that party. And we wrote up a beautiful statement. It was 36 pages long, and it contained a ton of law and all of the relevant facts, and we've had 5 years of litigation, so there's really a lot to explain to our mandatory settlement judge. And this, of course, the whole point of this procedure is to have a judge that isn't your regular judge in the case take a fresh look at things and look at the 2 briefs on the 2 sides and then speak with them candidly about what he or she thinks are the merits of that case and get the parties to maybe come together before they have to spend money on a trial. So it's a really important thing to do. Well, we filed our statement tonight, and the other side, in response, after we had spent all the money to do that, of course, sent an email saying, hey, we just don't think it's going to be fruitful to attend this. And so will you agree with us to take it off calendar? And we said, no, we don't agree, because the only way you can take it off calendar is to have both parties agree. And then they argued with us that they really didn't think that our statement was persuasive, but they didn't file any statement, so that's really not persuasive. And we think it's all the more reason why we need our judge, our mandatory settlement conference judge, to take a look at the situation and maybe advise them that they have a weak position, which indeed we think that they do. And so we'll be pressing forward with the mandatory settlement conference, and if they don't show up, then they are likely to be sanctioned because, consistent with the name, it is a mandatory settlement conference, and there isn't an opportunity to just opt out when you feel like you don't want to talk with the other side.